It looks like the Arcelor bid for Essar Steel has been approved. Let me just go across to our guests, all of them on the phone line with us. Mr. Ranina, let me start off with you on the latest news coming out of the NCLT with regards to those bids, and just get your first take on the Essar Steel case update. The NCLT has rejected Prashant Ruia's plea against Arcelor's bid.
Well, that was expected because the Ruias can't keep on, doing things after the application of ArcelorMittal has almost been approved. And I think it is ridiculous for promoters to just wait till the last minute and then, put in a bid which is higher than what others are doing. So really speaking, it is the right decision, and it gives the right signals that they cannot keep on, changing their stand all the time. And if they want to revive the company, they should do so before the matter goes to the NCLT.
Absolutely. And Ashvin, just taking a leaf from what Mr. Ranina said, that this verdict sends the right messaging across.
Yeah, so two observations. One, of course, is it's a very, very good message. I mean, quite loud and clear that the promoter, and then particularly there are several dimensions about this promoter also which need to be examined. It's not just the promoter and value maximization. I mean, if you have a case where the promoter has other businesses and which are also, considered as default cases. And therefore, to that extent, to step into this particular, let's say, initiative, this particular transaction, and then to put, try and create some kind of roadblocks, to begin with, was not a very acceptable proposition, and I'm glad that this is the outcome of this court decision. But I would, once I've read we have to read the order, we have to really go through the order. If it becomes a good precedent, it becomes a good, judgment for the other courts, for the other cases to be quoted, then I suppose it would really go a long way in terms of clarifying, very clearly how exactly promoters, that is those promoters who actually defaulted in the first place, and how does really the NCLT view them, coming into this process is something which is very interesting. The Act is very clear about it now after the amendment, but I thought, the order will give some more, throw some more light to it. So I would say a remarkable judgment. And it was on expected lines, but the detail will tell us more about, how far really in other cases this particular, this judgment can be used then.
Okay, let me also go across to Rajendra Chithale, who's also with us. Rajendra, let me get your view. And, it's really about the precedent here, because in terms of the execution, in terms of resolving some of these, major plans going forward, what would you take away from this? Are there still any other legal ramifications back and forth that we could potentially see, or will this now be smooth sailing for Arcelor?
Well, I would think that it should be smooth sailing from here on. I think if you look at what NCLAT had indicated even in the May hearings when this matter was discussed, they had chided the Ruias for basically trying to delay the whole resolution plan, which was already approved by the NCLT. And therefore, this is frankly only endorsing the sentiments which were kind of expressed by the NCLT in May. And therefore, now this finds itself an expression in the formal order. And hopefully, there is no further misadventure which continues on the part of Ruias to go to the Supreme Court against the NCLAT order and try to delay the whole thing further.
Mr. Ranina, just wanted to, stretch that point forward. Do you think that there's going to be a challenge of the verdict perhaps by the banks?
Well, I don't know whether they'll do it or not, but if the order is properly given and if it's properly worded, and there are cogent reasons that are given by the NCLT, then I think it would be futile and waste of time and money to go to the Supreme Court. And of course, they're free to do it. Everybody is free to do what he wants to do. But obviously, it would be a waste of time and would give the wrong signals to the investors that you're just trying to stall the process and not allow the resolution process to go through.
Hi, Mr. Ranina. This is Nayantara Rai in New Delhi. This is not just about Prashant Ruia and the Essar founders' plea being rejected. This is perhaps India's most fierce corporate battle since Cyrus Mistry and Ratan Tata's for the control of Tata Sons. It's that big. 42,000 crore rupees at stake to rescue and recover Essar Steel. Having said that, this was being seen as an asset case for insolvency and bankruptcy court. Perhaps the biggest case. We're talking about 42,000 crore rupees over here. When the NCLAT says modifications, is it giving a shot in the arm for creditors like, let's say, Standard Chartered? Because then, therefore, that's going to become the precedent for all other cases where smaller creditors who may not be secured will demand a larger share of the pie, and rightly so, with what the NCLAT has said.
Well, as Mr. Ashvin Parekh rightly says, we have to read the order, find out what is the rationale given in the judgment of the NCLT, and then take a view whether it will have a binding effect on other cases in future and whether operational creditors will get some benefit out of it. So not having read the order, I can't comment on this. But obviously, this is, as you rightly say, it is a landmark decision of the largest corporate battle. And certainly it will have a tremendous value as and when the judgment is analyzed and it is then applied to other cases, depending on the facts of each case.
Of course, we're waiting for the written copy of the verdict. It is being pronounced as we speak in New Delhi at the NCLAT. Mr. Parekh, let me come to you now. Like I was saying, India's fiercest corporate battle, where you've seen other industrialists like Anil Agarwal of Vedanta try to throw in his hat in the ring. We've seen Sajjan Jindal of JSW also try the same. In fact, I'm going to prompt my producers on live television to maybe try and reach out to Mr. Anil Agarwal of Vedanta. He's been an important member of this fierce corporate battle. Having said that, Ashvin Parekh, what's going to be the biggest takeaway when you look at this fierce corporate battle? Like I said, you've had large industrialists who have been part of it. Look at the kind of banks that we are also talking about. And do you honestly believe that this is the end of it? If we've seen one thing in the last 18 months, so the Ruias have refused to go down. They refused to get defeated. Do you fear that perhaps this case could get dragged on? And then having said that, how can the banks stand to gain? What kind of checks and balances are needed for that?
Yeah, so I mean, let's look at the options available, let's say, to the stakeholders. I mean, both the bankers and the promoters. I mean, I would certainly say that when the wording of the order will really play a larger role over here. But, I mean, the only hope is that there is no further wastage of time. That having said that, I must say that this case can really go a long way. I mean, let me articulate my thoughts. See, I mean, what we've done is, I mean, in the last 3-4 years now, we've introduced a major reform. We are really empowering the financial lenders, at least to begin with. And then when it comes to financial lenders versus the other creditors, I mean, I would certainly say that that's another matter altogether. I mean, there are two issues over here. One is the promoter putting a stake, and the second one is the waterfall situation in terms of who gets what out of the recovery. I would certainly say that waterfall kind of judgments may follow. I mean, because depending on each case, we may have to examine, and then see how exactly the resolution money has to be distributed. But to my mind, that's the second process. The first part, which is trying to resolve the asset, and make sure that financial lenders get that is after the haircuts their money back. That is a major milestone. I mean, to my mind, waterfall and waterfall related on a case-to-case basis will keep on coming up on a regular basis thereafter.
Gentlemen, I'd like to thank you. It's India's largest, fiercest corporate battle, perhaps the fiercest one since Ratan Tata and Cyrus Mistry. An important outcome at the NCLAT. We have to take a short commercial break.